What is PTSD? A service member who has deployed in any conflict may experience trauma that leads to post-traumatic stress disorder, also known as PTSD. This is an issue that many veterans returning from Iraq and Afghanistan have to deal with. Common symptoms of PTSD include the following. 1. Reliving the traumatic event or events. 2. Avoiding situations that remind the service member of the traumatic event or events. 3. Negative changes in the service member's belief or feelings. And 4. Hyperarousal. The service member may feel jittery, always on alert, and or always be on the lookout for danger. This can also manifest itself in an inability to concentrate or sleep. The fact that a service member suffers from PTSD may be an issue when requesting custody and visitation rights in family law proceedings. Custody overview. The family law judge may only consider the best interests of the child or children in a child custody case. Only issues relating to a child's health, safety, and welfare can be considered by the family law judge when making a custody or visitation order. In determining what is the best interest of a child, a family law judge may consider any relevant factor to parenting. This includes whether or not a service member parent suffers from PTSD. Child custody and PTSD. In a contested child custody case, the non-service member spouse will often cite the service member's behavior associated with PTSD to bolster his or her case that the service member should not have custody of their child, or that visitation should be supervised. Merely having PTSD will not cause a service member to lose custody. However, a family law judge will take the effects of the service member's PTSD into consideration when making a custody or visitation order. Proving PTSD as the non-service member spouse. Anyone can allege PTSD, but proving it is a different matter. The non-service member spouse can go about this in the following ways. 1. Showing specific actions that link the PTSD to the service member being unfit for custody or visitation. And 2. By showing the service member's medical record to the court as a way of proving that the service member is an unfit parent. If the non-service member spouse cannot show specific actions on the part of the service member that shows him or her to be unfit for custody or visitation, then the non-service member can attempt to use the service member's medical record to do so. The non-service member can get access to the service member's medical record in the following ways. First, if the service member brings up his or her medical or psychiatric issues, then the service member has what they say, open the door for the non-service member to have access to the service member's medical or psychiatric records. Secondly, the non-service member spouse can subpoena the medical and or psychiatric records of the service member. In California, to get the service member's medical or psychiatric records, the court will weigh the service member's right to privacy against the best interest of the child. The burden of overcoming the service member's right to privacy will be on the non-service member spouse. The non-service member spouse can also subpoena the service member's doctor and or psychiatrist. This is even harder than getting the service member's medical or psychiatric records, as the non-service member spouse will have to overcome not only the service member's right to privacy, but also the right of the doctor-patient confidentiality. An example of this situation would look something like this. 1. The non-service member spouse claims that the service member is suicidal because of his PTSD and suffers from morbid thoughts. 2. The non-service member spouse further claims that these PTSD symptoms make the service member a danger to their children. Because of this, the non-service member spouse argues that the service member should not get custody of their children and should only be allowed supervised visitation. Because the non-service member spouse cannot show any specific incidents, the non-service member spouse tries to subpoena the service member's medical record and psychiatrist. Since the service member never opened the door by bringing up these issues, the service member argues that the non-service member spouse should be denied access to both the records and the psychiatrist. The family law judge then must weigh the interests of the children against the service member's right to privacy and the doctor-patient confidentiality. PTSD, service member's perspective. A service member with PTSD who is going through a custody dispute should seek mental help, to include psychiatric help. The veteran can use the mental health professionals to show that the PTSD that has not caused symptoms that would affect custody and visitation rights. If there are documented incidents, the service member can use the mental health professional's opinion to reduce the damage done. It also can convince a judge that the service member is actively seeking help and not a threat to the children. However, this is a very slippery slope. If the service member uses the declaration or testimony of a mental health professional, the service member has opened the door for the non-service member spouse. The service member has waived his or her right to privacy and the doctor-patient confidentiality. The non-service member will thus be able to request access to the service member's medical records and/or treating mental health professionals. Takeaways. Merely being in the military or suffering from PTSD will not make a service member lose custody or visitation rights. However, the court will take into account documented PTSD symptoms when determining what is in the best interest of the child.